Can an estate planning attorney be held liable for malpractice by the personal representative of the estate? To find out, you have to read Schneider versus Finman, but it's 6 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is part of a limited series I'm covering on landmark cases of interest to estate planning and elder law attorneys. This is the episode on the case of Schneider versus Finman. The citation for this case is 2010 New York Slip Opinion 5281, published by the New York Court of Appeals on June 17th of 2010. The issue in this case and why it's a landmark case is the question is, can a decedent's estate, so can the personal representative of a decedent's estate sue the decedent's attorney for estate planning malpractice? The law you have to understand to appreciate the context of this case and why it matters is first the concept of privity. Privity is a concept under the law that says there has to be a relationship, a connection or direct connection between the person that suffered the harm and the person being sued for the harm. So you have to have that connection in order to sue in order to have liability to each other under negligence or malpractice. So in negligence and malpractice actions, the rule has always been in New York until this case that a third party without privity, so a party that has not been in direct connection with the party being sued, cannot maintain a claim against an attorney for professional negligence unless there is fraud, collusion, malicious acts, or other special circumstances. Absent those limited categories, a party that's not in privity cannot initiate a lawsuit for malpractice. It's part of so the elements of negligence are duty, breach, causation, and damage. Part of the elements of duty is you owe a duty to someone you're in connection with. You can't sue someone that you have no connection with for the breach of a duty. So what are the facts here? The facts are that there was a human being named Saul Schneider who retained the defendant attorneys between April of 2000 and October of 2006 to prepare estate planning documents to help him facilitate estate planning so that he'd have limited liability when he died, so most of his estate would avoid tax liability. In April of 2000, Schneider bought a $1 million life insurance policy. And under the advice of the defense counsel, the attorneys who are the defendants in this case, they advised him or failed to advise him not to do this. Schneider transferred ownership of that $1 million policy over and over and over and over again, which created a problem when he died. When he died, the proceeds of that life insurance policy were included as part of his gross taxable estate, which means the tax man gets more of his estate, more of the proceeds than they would otherwise have been able to get if he had been properly advised, according to the complaint. So the estate of Schneider, the personal representative of his estate, brought a lawsuit against the attorneys who had provided this estate planning concept, these ideas, this advice, for malpractice, for negligently advising Schneider when he was alive about the transfers of ownership of the life insurance policy, which resulted, the harm is alleged to be, the increased tax liability. In response to the procedural history here is that the attorney, the defendant attorney here, moved to dismiss. He moved to dismiss, saying failure to state a cause of action. I don't have any privity with the estate of Mr. Schneider. In fact, that estate of Schneider didn't exist when I was having my relationship with Mr. Schneider. I have no relationship with them. In fact, they didn't exist. And beyond that, the cause of action didn't exist until Mr. Schneider died. So the Supreme Court granted the motion to dismiss, said, you're right, there's no privity here. The appellate division affirmed what the Supreme Court had done, saying there's no privity. They agreed. It goes to the Court of Appeals. And here we have the holding, which is a new rule. The new rule, this is why it's a landmark case. It doesn't erase the need for privity. They're not saying you don't need privity anymore. But what they're doing is they're saying that privity or a relationship sufficiently like privity exists. They're basically saying as a matter of law that privity exists between the personal representative of an estate and the estate planning attorney. They're creating a new law that that person who represents the decedent has privity with the attorney. because they were expected to be the recipients of the services of the attorney. They say the estate stands in the shoes of the decedent. So if the decedent had privity, then so too does the personal representative of the estate. And the personal representative can maintain, that's the new rule, they can maintain an action of legal malpractice for the losses at the estate. But they're quick to note that they're not extending privity to everybody. In fact, they specifically maintain that the strict privity rule still is a bar to beneficiaries and other third parties that are not the personal representative of the estate. But what's interesting about this is the attorneys were correct in some sense that the malpractice hadn't yet occurred by the time the Schneider had died. It occurred, the harm existed when Schneider died and the tax liability arose. So this new rule doesn't just expand privity. They're saying that beyond privity, the estate representative can sue for malpractice, even though the decedent may not have had an active cause of action at that time. So it's creating a new rule both of liability and privity. And that's the case of Schneider versus Finman. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.